Hi, so it's me again, and for this video, we will be discussing crimes against persons. Book 2 na to. As I mentioned earlier, na yung sinusunod ko is the San Beda College of Law syllabus. So sa CrimRev, yung first discussion for Book 2 is crimes against persons. Okay, so Parricide. Parricide is a crime involving the destruction of life wherein there is a relationship between the offender or the accused and the offended party or the victim. So ano yung elements? First, a person is killed. Second, the deceased is killed by the accused or the offender. And third, the deceased is the accused's legitimate or illegitimate father, legitimate or illegitimate mother, legitimate or illegitimate child, which should not be less than 3 days old. Kasi kapag ka less than 3 days old yan, hindi yan parricide, infanticide yan. Next is other legitimate ascendant. Dapat legitimate hindi illegitimate. Next is other legitimate descendant or legitimate spouse. So, tandaan natin na kapag ka father, mother, or parents, dapat legitimate or illegitimate, meaning biological. It doesn't matter kung legitimate or illegitimate. Basta, nanay or tatay niya yan. Yung nanay or tatay, yung pumatay. Or pwedeng anak, biological na anak, regardless kung legitimate or illegitimate, as long as hindi less than 3 days old. Kasi kapag less than 3 days old, again, infanticide. Kapag ka-ascendant naman, other ascendants, di ba yung parents mo, ascendant mo rin. Pero, exception yung parents, kasi sa parents, it doesn't matter kung legitimate or illegitimate. However, kapag lolo, lola, and up na, pataas na yan, kahit great-grandparents mo pa, dapat legitimate para maging parricide. Other legitimate descendant naman with the exception ng anak. Kasi kapag anak, kahit legitimate or illegitimate, pasok yan sa parricide. Kapag ka-apo, pababa, apo sa tuhod, mga ganyan, dapat legitimate yung descendant. And kapag ka-asawa naman, dapat kasal, legitimate spouse. Hindi pwedeng common law spouse, yung nagli-live-in lang kayo pero hindi kayo married. So bakit importante na i-memorize natin kung ano yung mga relationships na to na nagka-qualify ng killing into parricide? Kasi mas mataas yung penalty for parricide. So yung defense lawyer, as much as possible, ayaw niyang maging parricide yan. Yung prosecution naman, as much as possible, gusto nilang ipasok yung parricide dyan kasi mas malala yung penalty or yung punishment kapag ka parricide. Kasi mas perverse naman talaga. Imagine, pamilya mo, kadugo mo, pinatay mo, 'di ba? So, yun yung parricide. Relationship must be alleged in the information to be convicted of parricide. Relationship of offender with the victim is an essential element of this crime. Except for spouses. Kasi yung spouses, ito lang yung hindi by blood, 'di ba? Lahat ng minention earlier, ascendants, descendants, anak, parent, lahat yan connected by blood. Except the spouse. Kasi connected by marriage yan. So, lahat by blood and indirect line. Pansin nyo, walang sister, brother, walang sibling, walang cousin. So, direct lang siya, linear lang. Ascendant, descendant, except sa asawa. Yun lang yung hindi direct line na by blood. So, question, adopted child, pasok ba sa parricide? Hindi. Kasi, again, statutory construction, kung may enumeration, exclusive yan. Unless na nagsabi na hindi exclusive yung list. So, ano pa? Best proof of relationship ng spouses para legitimate spouse na pasok sa parricide is marriage certificate, of course. In the absence of such marriage certificate, however, oral evidence of the fact of marriage may be considered by the trial court if such proof is not objected to. If the information failed to allege marriage between the offender and the offended party, the former cannot be convicted of parricide. So, pwedeng homicide, pwedeng murder, di-discuss natin later as the case may be, magkaiba yan. Muslim husbands, di ba pwede silang maraming wives? So, Muslim husbands with several wives can be convicted only in case the first wife is killed. So, other wives, second wife, and so forth, hindi na yan parricide, murder or homicide as the case may be. So, adoptive parents naman, hindi rin included. So, adopted children or adoptive parents, hindi included sa parricide. Can parricide be committed through reckless imprudence? Yes. So, reckless imprudence resulting to parricide, pwede. Parricide shall not be punished by reclusion perpetua to death in the following cases. Kapag ka reckless or simple imprudence, kapag ka parricide by mistake, and parricide under exceptional circumstances. Yung parricide under exceptional circumstances, i-discuss natin after nito. Yung 247, very important. So, paano pag may stranger na nag-cooperate and takes part in the commission of the crime of parricide? So, yung relationship, part ng element, diba? Yung stranger, diba kapag ka may conspiracy, kung ano yung crime ng isa, crime ng lahat. However, yung relationship kasi personal. So, yung stranger na co-conspirator ng isang person na nag-commit ng parricide, hindi siya guilty of parricide, homicide, or murder as the case may be sa kanya. Kasi yung relationship, wala siya eh. Yung key element always ng parricide is relationship of the offender with the victim. If a person wanted to kill a stranger but by mistake killed his own father, he will be liable for parricide, but Article 49 will apply as regards the proper penalty imposed. That is the penalty for the lesser offense in its maximum period. Because knowledge, may liability pa rin, because knowledge of relationship is not required by law to be liable for parricide. Okay. If the marriage is void naman, meron bang parricide? Of course, wala. However, if the marriage is void due to Article 36 of the Family Code, which is psychological incapacity, whether or not the crime is parricide depends on when the crime was committed. So, if the marriage was subsisting at the time of the killing, then of course parricide. Otherwise, homicide or murder as the case may be. Annulment of marriage is not a prejudicial question in a prosecution for parricide. Hindi pwedeng i-stop or i-pause yung prosecution for parricide just because merong kaso pa sa annulment of marriage na uunahin talaga yon. The issue in the former is not intimately related to the issue in the latter. Further, the relationship between the offender and the victim is not determinative of the guilt of the innocence of the accused. Marital violence that leads to the killing of the spouse is still parricide. Pagka, for example, woman beater or wife beater yung husband, tapos sinaktan niya ng sinaktan hanggang sa namatay, that's still parricide. Kasi, pasok siya sa elements. Ano ba yung elements? May killing, siya yung pumatay, meron silang relationship, legitimate spouse. The law does not require knowledge of the relationship, Thus, a person who killed another unaware of the relationship, pero later na prove na meron pala silang relationship na pasok dun sa parricide, it's still parricide. Guilty pa rin of parricide. Annulment of marriage is not, again, a prejudicial question in a prosecution for parricide. Now let's go to Article 247, death or physical injuries under exceptional circumstances. Article 247. Yung Article 247 is not a felony. It does not define a felony. Rather, it serves as a defense for a person charged with parricide, homicide, or serious physical injuries. If all the requisites have been met, the defendant will be sentenced to destierro instead of the severe penalty for the aforementioned crime. So, instead parricide kapag yung pinatay is asawa niya or anak niya, as the case may be, kasi pasok yan dito sa exceptional circumstances or homicide kapag Hindi niya yung kasi dito kapag pinatay, pwede kasing pinatay ng accused yung asawa niya and yung partner niya or yung paramour niya. So syempre wala naman siyang relationship dun sa paramour, so hindi pwedeng parricide yon. So homicide yon. Or serious physical injuries kapag ka hindi namatay. So ano yung requisites? Requisites yung tawag dito na term, hindi elements, kasi hindi nga ito nagde-define ng felony. So, requisites. Dalawa kasi yan. Dalawang uri yan. Yung Article 247. Sa asawa at sa anak. Okay, dun muna tayo sa asawa. A legally married person surprises, okay, a legally married person surprises his or her spouse in the act of sexual intercourse with another person. Sexual intercourse, ha? Kapag sinabi mong surprise, to come upon suddenly and unexpectedly. Hindi nga pinlano, hindi nga stinok, hindi nga sinet up. Nahuli lang niya. Na-shock siya. May shock element. Na-surprise siya. Na-surprise siya, nahuli niya na nagsisexual intercourse. Ano yung sexual intercourse? May vaginal penetration by the penis. So, hindi pwede na magkatabi lang sila natutulog, nagkakadal-kadal lang sila, nagmamomo lang sila, hindi rin pwede homosexual. Kasi, kailangan sexual intercourse, hindi sexual act, intercourse, may penetration ng penis sa vagina. That, after niyang ma-surprise na nagsisex yung asawa niya, the accused, he or she, pwedeng babae, pwedeng lalaki, kills any or both of them. So, pwedeng pinatay yung kasex ng asawa niya, or yung asawa niya, or dalawa sila. So, pag pinatay yung asawa niya, parricide yun. Kapag pinatay niya yung kasex ng asawa niya, homicide yun. Kapag both, edi parricide and homicide. Or, pwede rin hindi niya pinatay, inflicts any or both of them any serious physical injury in the act of sexual intercourse habang nagsisex, or immediately thereafter, pagkatapos mag-sex. Kapag immediately thereafter, the discovery, space, pursuit, and killing must all form part of one continuous act. So, sa jurisprudence and sa law, hindi sinasabi kung gaano katagal yung immediately thereafter. Case-to-case basis yan. Yung pinaka-basehan is na walang break, continuous siya. So, for example, dun sa case na nahuli niya yung asawa niya na nakikipag-sex, hindi niya pinatay agad kasi wala siyang weapon. Pero, umalis siya, naghanap siya ng weapon, tapos hinanap niya, after niya makahanap ng weapon, tapos binaril niya. So, entitled pa rin siya sa Article 247 sa case na to kasi continuous, unbroken. Simula sa time na nahuli niya, hindi na siya nagpatumpik-tumpik pa. Naghanap agad siya ng weapon kasi, 'di ba, nasa isip pa rin niya eh. Na-shock pa rin siya. Tuloy-tuloy yon, hindi siya nagpahinga. Hinanap niya, pinatay niya. So, pasok pa rin yun, continuous pa rin yun, kahit ilang hours na nakalipas. And that, the offender did not promote or facilitate the prostitution of his or her spouse, or hindi siya nag-consent sa infidelity or sa sex dun sa another person. Kasi, ang weird naman na pumayag ka or may arrangement kayo, alam mo na nakikipag-sex siya dyan, tapos papatayin mo sila, wala nang surprise factor doon, diba? So, yon. Yung isa namang uri is, instead na asawa, mahuli yung spouse niya na nakikipag-sex sa iba, daughter naman. Okay? So, ang parent, nahuli niya yung daughter niya, hindi son na, daughter niya na nakikipag-sex sa iba. Tapos, yung daughter dito, dapat below 18, independent pa nila. Hindi yung emancipated na or independent na. Syempre, malamang baka may asawa na yung daughter nila, 'di ba? or may ka-live-in, tapos self-sustaining na din naman. Hindi ganon. Dapat, nasa pamamahay pa nila, sinusupport pa nila, dependent pa sa kanila. Tapos nahuling nakikipag-sex. So, yon. And dapat andun pa rin yung surprise, yung act of sexual intercourse, dapat immediately thereafter, and dapat hindi nag-consent dun sa ginagawa ng daughter or hindi pinrostitute yung daughter. So, bakit may ganito? Kapag kapasok kasi sa requisites, instead na i-punish for parricide or homicide or serious physical injuries as the case may be, hindi ikukulong. Para siyang exemption, exceptional circumstance siya. Yung merong penalty pero destiero lang. Yung justification is that the law considers the spouse or parent as acting in a justified burst of passion. Kapag ka less serious or slight physical injuries yung na-inflict, meron bang criminal liability? Wala. Ni destiero, wala. Kapag ka serious physical injury naman, destiero. Actual sexual intercourse is required. The accused must be legally married kapag ka spouse, and the victim must be his or her spouse. Pwede naman yung partner lang yung pinatay pero dapat ka-sex nung asawa niya. Whether or not the daughter, kapag daughter yung case, is legitimate or illegitimate is immaterial, provided that she is living with a guilty parent. Privilege cannot be invoked without surprise. If the accused did not surprise the supposed offenders in the very act of committing adultery, he cannot invoke the privilege of Article 247. Again, there is no set time, as jurisprudence has held 1 hour or even 4 hours as immediately thereafter. However, the act done must be a direct result of the outrage of the cuckolded spouse, and cuckolded meaning nakita ng asawa na nakikipag-sex yung asawa niya sa iba, and continuous act from the moment of the surprising. Article 247 does not apply if the surprising took place before any actual sexual intercourse. Again, kapag momol-momol pa lang or sabihin na nating foreplay pa lang, hindi siya entitled sa benefits ng Article 247. Dapat in the act of sexual intercourse or immediately thereafter. Article 247 only applies when the daughter is single, because while under 18 and single, she is still under parental authority. If she is married, her husband alone claim the benefits of this article. For a husband's act to be justified, it is not necessary that he sees the carnal act being committed by his wife with his own eyes. Hindi pwedeng hindi kailangan na nakita niyang pumasok talaga yung penis sa vagina ng wife niya, for example. It is enough that he surprises them under such circumstances as to reasonably show that carnal act is being committed or has just been committed. Obvious ba na nagsisex? The accused husband need not kill or inflict serious physical injuries upon his wife and or paramour at the place where he surprised them in flagrante delicto. Again, sa kwento ko, pwedeng naghanap muna siyang weapon, tumakas yung offenders ng adultery, tapos nagmadyong muna doon sa madyungan. Tapos doon niya pinatay sa madyungan. Pwede din yun. Pasok pa rin yun sa Article 247 provided that continuous yung act. Okay. So the death caused must be the proximate result of the outrage overwhelming the accused after chancing upon his spouse in the basest act of infidelity, which is sexual intercourse. If only less serious or slight physical injuries were inflicted, Article 247 shall operate as an absolutory cause. Okay? Again, as mentioned, wala talagang penalty to exculpate the accused from any criminal liability. Kasi ang weird naman, destiero, yung punishment mo for the killing and for serious physical injuries, tapos yung less serious physical injuries lang and slight physical injuries lang, mas mabigat pa yung penalty, 'di ba? It doesn't make sense. So kapag ka less serious or slight physical injuries, wala na talagang kahit ano. So persons not entitled under Article 247, any person who shall promote the prostitution of his wife or daughter, any person who shall facilitate the prostitution of his wife or daughter, or any person who shall consent to the infidelity of the other spouse. So murder naman. Murder, a crime committed if a person kills another and it is attended by qualifying circumstances laid out in Article 248 of the Revised Penal Code. Mali yung sinasabi nila pag may namatay, murder agad. Hindi. Kapag may namatay lang, homicide yon. Pero huli natin i-discuss yung homicide kasi dapat alam muna natin yung lahat ng pagpatay na hindi homicide para kung hindi siya parricide, kung hindi siya infanticide, kung hindi siya murder, homicide siya. Ganun lang yon. So murder, pagpatay na may qualifying circumstances. So dapat memorize natin yung qualifying circumstances na to. Okay, there's no way around it. So first element, a person is killed. Second, the accused killed such person. Yung mga elements actually hindi na kailangang i-memorize eh. Basta naiintindihan mo yung crime, pwede mo nang gawin yung elements eh, in your own words. So murder, may pinatay. So, first element, a person is killed. 'Di ba? Second, anong next element? Dapat na para element kasi kailangan kompleto yung elements para maging guilty yung isang tao. So, paano? Dapat, yung akusado, yung suspect, yung offender, dapat siya yung pumatay dun sa namatay. Kasi, walang liability kapag hindi siya yung pumatay nun, right? So, ganon. Accused killed such person. Next element, the killing was attended by any. Meaning, kahit isa lang dyan, hindi kailangang lahat ng circumstances kompleto. Pili ka lang dyan. Kung prosecutor ka, pili ka lang dyan. Kapag may qualifying circumstances dyan na existing, na nag-attend dun sa killing, then it is murder. So, the killing was attended by any of the qualifying circumstances. So, first, with treachery. Yun yung una. Marami yung sinasabi with treachery, blah, 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 blah. Pero lahat yan, ina-absorb dun sa treachery. Okay? Pwedeng treachery lang, yun yung nag-qualify. Or pwedeng, for example, taking advantage of superior strength. Absorbed yan dun sa treachery. Isang paragraph lang yan sila pag babasahin mo yung Article 248. So, first qualifying circumstances. With treachery. Taking advantage of superior strength, aid of armed men, or employing means to weaken the defense, or of means or persons to ensure or afford impunity. Ano ba yung treachery? Pag sinabi mo kasing treachery, yung pinaka-layman na ma-explain ko siya in Tagalog is, hindi mo siya Taglish, sorry. Hindi mo siya nabigyan, yung pinatay mo, hindi mo nabigyan ng chance na i-defend yung sarili niya. Nagulat siya. Kasi, ikaw na accused, the way mo siyang pinatay, unexpected sa kanya, sudden sa kanya, hindi siya nakaprepare, unfair sa kanya, na wala talaga siyang palag. Yun lang yun. Hindi kailangang laging surprise attack. Hindi ganon. Pwedeng nakita kanyang papunta, pero ang dami-dami nyo. 'Di ba? Meron kang aid of armed men. Ano pang palag niya na corner na siya ng armed men, 'di ba? So, wala siyang takas. Wala siyang palag. Or taking advantage of superior strength. Given the circumstances, wala talaga siyang palag. Kaya kapag ka bata yung pinatay at hindi siya pasok for example sa infanticide, automatic murder yon kapag tender age. Kasi anong laban ng bata sa'yo? 'Di ba? Kung adult ka na. So, treachery, pasok pa rin yon sa treachery kasi you took advantage of your superior strength being an adult, a fully formed adult, sa child of tender years. Or any means to weaken the defense of a person. So, you can get creative. Basta, parang hindi siya naka-prepare, hindi siya naka-defend properly ng self niya, treachery yun. Or, gumamit ka ng means or persons that will ensure and afford impunity na kaya mo siyang patayin na hindi ka mababalikan. Pinatay mo siya in a way na wala siyang palag na ikaw hindi mamamatay. Hindi siya fair fight. Wala kang risk sa sarili mo. Kasi yung means or methods na in-employ mo, sinigurado mo na eh. Ganon. Walang danger sa self mo. Kasi kapag, for example, nag-quarrel kayo, nag-away kayo, alam mo na pag intense na yung away mo, alam nyo ng dalawa na baka magkasakitan kayo, right? So, merong build-up. Hindi mo siya in-expect. Tapos ikaw, habang nagbe-build up yung away nyo na parang hahantong na sa patayan, kayong dalawa na nag-aaway, delikado kayong dalawa. Kasi, pag magkapalaga na, 50-50 kung sino yung mananalo dyan, kung sino yung mabubuhay, kung sino yung mamamatay, or parehas kayong mamamatay. Pero pag may treachery, meron kang advantage sa kanya. Talagang, papatayin ko to in a way na hindi ako mapapatay. Siya lang yung mamamatay. Sigurado. Parang ganon. Yun yung treachery. So sorry about that. So, continuing, next qualifying circumstance is in consideration of a price, reward, or promise. So, self-explanatory na din naman. Like, for example, if gun for hire, mga ganyan, price is babayaran. Reward is pagkatapos gawin, merong reward, merong bounty. Promise is a promise na magkakaroon ng prize or ng reward or some sort of favor or incentive after the killing is done. Okay. So, next qualifying circumstance is by means of inundation, fire, poison, explosion, shipwreck, stranding of a vessel, derailment or assault upon a railroad, fall of an airship, by means of motor vehicles, or with use of any other means involving great waste and ruin. So, lahat ng yan, 'di ba? May maraming casualties. Yung method na pinili, hindi lang siya parang overkill, ganon. So, inundation, ito yung ida-drown. Wait lang, check ko kung tama. Inundation. Flooding, yes. So, paano i-memorize to? Una, flooding. Yan. By means of fire. Iba to sa arson kasi sa arson, destruction of property. Ito, ginamit yung fire not to destroy property but to kill someone. So, una is flooding, inundation, fire, poison, explosion, shipwreck. Sisirain mo yung ship para mamatay yung gusto mong patayin. Isa-strand mo yung vessel, any kind of vessel. Derailment or assault upon a railroad. Fall of an airship by means of motor vehicles. So, para ma-memorize to, isipin na lang natin yung lahat ng uri ng vehicles, ng motor vehicles at lahat ng vessels. Tapos, sisirain yan in order to kill someone. Parang ganyan. Or any other means involving great waste and ruin. Meaning, hindi to exclusive list. Kahit ano na parang involving great waste and ruin, yun, kasama yun sa qualifying circumstance na to. On occasion of any calamities enumerated in the preceding paragraph, so yung mentioned, inundation, fire, poison, explosion, shipwreck, stranding of a vessel, derailment or assault upon a railroad, fall of an airship by means of motor vehicles, or with use of any other means involving great waste and ruin. So, habang nangyayari yan, hindi siya, yung difference is, sa una, siya yung nag-cause ng mga ganito, ng mga means involving great waste and ruin. Siya yung gumawa nun in order to kill someone. Dito naman, nangyari lang, pwedeng accident, pwedeng ibang tao yung gumawa, tinake advantage yung situation na may ganito in order to facilitate the killing of someone. Or pwede rin calamity, such as earthquake, eruption of a volcano, destructive cyclone, epidemic, or any other public calamity. So, pwede ring bagyo. Next is with evident premeditation. So, i-discuss natin later kung ano yung requisites ng evident premeditation. Pero, basically, pinagplanuhan. Yun. With cruelty, by deliberately or inhumanely augmenting the suffering of the victim or outraging or scoffing at his person or corpse. Yun yung last qualifying circumstance. So, outraging is to commit an extremely vicious or deeply insulting act, like the act of having anal intercourse with a woman after killing her. May case na ganito. Scoffing is to leer and implies a showing of irreverence. An example is when the intestines of the dead were removed and hung around the neck of the victim's brother as a necklace, and the lungs and liver were described as pulutan. Last element is that the killing must not be parricide or infanticide. If there are more than one qualifying circumstance alleged in the information for murder, only one will qualify the killing to murder, and the other circumstances will be taken as generic aggravating circumstance. So, na-discuss na natin sa previous video kung anong generic aggravating circumstances. When the other circumstances are absorbed or included in one qualifying circumstance, such as what I explained regarding treachery, they cannot be considered as generic aggravating circumstance. So, pag na-absorb na yan, for example, merong advantage of superior strength, merong aid of armed men, lahat yan treachery. Hindi mo kukunin na advantage of superior strength, tapos iibahin mo pa yung aid of armed men, hindi ganon. So, isa lang sila. Any of the qualifying circumstances enumerated in Article 248 must be alleged in the information. Kasi kung hindi i-allege, homicide lang siya. As a general rule, the offender must have intent to kill to be liable for murder. Except if it is qualified by treachery, then it is required only that there is treachery in the attack. Hence, there is murder even if the offender has no intent to kill the person assaulted, basta may treachery. If the primordial criminal intent of the offender is to kill and fire, yun yung diniscuss ko kanina, was only used as a means to do so, crime is murder, hindi siya arson. Treachery and evident premeditation are inherent in murder by means of poison. So, dahil nga, ginamit na siya as poison, kapag poison yung ginamit, hindi na pwedeng mag-treachery pa or mag-evident premeditation, poison na. Absorbed na siya dun sa poison. Hindi na pwedeng gamitin as aggravating circumstance. Although issued with license to possess firearms, carrying such firearms outside the residence, and unauthorized use thereof in killing may be appreciated, may be appreciated as an aggravating circumstance in imposing penalty for murder. So, rules for the application of the circumstances which qualify killing to murder. So, the following are the rules. First, only one qualifying circumstance described in Article 248 is necessary to qualify the offense as murder. When the other circumstances are absorbed or included in one qualifying circumstance, they cannot be considered as generic aggravating circumstances, and any of the qualifying circumstances enumerated in Article 248 must be alleged in the information. So, iisa-isahin natin ulit. Treachery. In order for treachery to be properly appreciated, two elements must be present. At the time of the attack, the victim was not in a position to defend himself, and the accused consciously and deliberately adopted the particular means, methods, or form of attack employed by him. So, pwedeng treachery. Pero pag merong advantage of superior strength, absorb na rin yun sa treachery. Pero kung wala yung advantage of superior strength, wala yung aid of armed men, walang employing means to weaken the defense, then, ito, yung treachery, sufficient na. Kasi yung treachery na to, means or persons na to ensure or afford impunity, ito na yon. Kasi, notice nyo sa second element ng treachery, di ba? The accused consciously and deliberately adopted the particular means, methods, or forms of attack employed by him. And the victim was not in a position to defend himself as previously discussed. The essence of treachery is the sudden attack by an aggressor without the slightest provocation on the part of the victim, depriving the latter of any real chance to defend himself, thereby ensuring the commission of the crime without risk to the aggressor, as I explained exhaustively earlier. Mere suddenness of the attack does not amount to treachery, and killing of a child of tender years is murder, even if the manner of attack is not shown. So, price, reward, or promise, the person who received the price or reward, or who accepted a promise or reward, and who would not have killed the victim were it not. So, importante na yung nag-compel sa kanya, yung reason bakit siya pumatay is because of the price, reward, or promise. So, yung pumatay, principal by direct participation. And the one who gave the price or reward or who made the promise is a principal by inducement. Okay, so fire. There should be an actual design to kill, and that the use of fire should be purposely adopted as a means to that end. By means of explosion, since the use of explosives is the principal mode of attack, reason dictates that this attendant circumstance should qualify the offense instead of treachery, which will then be relegated merely as a generic aggravating circumstance. So, on occasion of inundation, shipwreck, etc., of an earthquake, eruption of a volcano, epidemic, or any other public calamity, the killing of a person on these occasions, when taken advantage by the offender, qualifies a crime to murder. So, eto na evident premeditation. Ito yung requisites ng evident premeditation, very important. First, the time when the offender has determined to commit the crime. So, si offender, nag-decide, okay, I'm gonna commit this crime. Determined na siya. Nag-decide siya na gagawin niya. Papatayin niya. Second, there is an overt act manifestly indicating that the culprit or the offender or the accused has clung to his determination. Determination to kill. Determination to commit the crime. And there is a sufficient interval of time between that determination na nag-decide siya and, hindi yung act manifestly indicating and the execution of the crime. The time kung kailan kinumit yung murder has lapsed to allow him to reflect upon the consequences of his act. So, merong interval of time, merong period of time between the time na nag-decide siya to commit the act. Syempre, hindi natin malalaman yan kasi mental exercise. That's why kailangan may overt act na nag-i-indicate na nag-decide siya mag-commit ng crime and talagang pinursu niya ang pag-commit ng crime. And then, pinatay niya. So, yung period of time in between, dapat long enough para maging evident premeditation. Kasi, sa evident premeditation, baliktad siya ng passion or obfuscation. Hindi siya dala ng emosyon kung bakit niya pinatay yung tao. Pinagplanuhan niya talaga, pinag-isipan niya. So, napaka-perverse. Kasi, you had time to coolly reflect on the consequences of your action. Pero decided ka talaga. Yun yung pinapunish dyan sa evident premeditation. Cruelty. There is cruelty when other injuries or wounds are inflicted deliberately by the offender, which are not necessary for the killing of the victim. The victim must be alive when the other injuries or wounds are inflicted. There is cruelty when the culprit enjoys and delights in making his victim suffer slowly and gradually, causing him unnecessary physical pain in the consummation of the criminal act. So, imbis na patayin na lang niya, papahirapan pa niya, parang ito-torture pa niya. In cruelty and ignominy, the intention of the accused is to augment or to increase the physical and moral suffering of the victim, respectively. Hence, these circumstances cannot be considered if the subject act was committed at the time the victim was already dead, since a dead person, of course, doesn't suffer anymore. Outraging naman is an extremely vicious and deeply insulting act. Outraging or scoffing is either at the person of the victim or at the corpse of the victim. Hence, scoffing can be considered even though the outrageous act was committed at the time that the victim is already dead. So sa cruelty and ignominy, kailangan buhay kasi suffering eh. Pinahirapan mo pa. Outraging naman, binastos mo pa, binaboy mo pa. Kahit patay na. Scoffing means to jeer and implies a showing of irreverence. In scoffing the victim, the accused must already be dead after the acts were committed. Cutting the head of a dying victim after the infliction of a mortal wound is cruelty or scoffing. Raping a dying victim after the infliction of a mortal wound on her is cruelty, ignominy, and scoffing. Bakit may cruelty? Kasi habang buhay siya, imagine, imbis na patayin mo lang, cut mo pa yung head or i-rape mo pa. Loose firearm. It refers to an unregistered firearm, an obliterated or altered firearm, a firearm that has been lost or stolen, illegally manufactured firearms, registered firearms in the possession of an individual other than the licensee, and those with revoked licenses in accordance with the rules and regulations. So the use of loose firearm when inherent in the commission of a crime punishable under RPC or other special laws shall be considered as an aggravating circumstance. The intent of Congress is to treat the offense of illegal possession of firearm in the commission of homicide or murder with the use of unlicensed firearm as a single offense. So last nating i-discuss is homicide. Tapos ito na siguro yung part 1 and yung ibang crimes against persons next video na lang. Homicide, Article 249. The unlawful killing of a person which is neither parricide, murder, or infanticide, kaya inuna natin yon. Yung elements niya is a person is killed and the accused killed such person without justifying circumstances. Kasi pag may justifying circumstances, ibig sabihin may liability. Pag accepting circumstance naman, meron pa ring crime, wala lang punishment. Pero sa justifying circumstance, wala talagang crime. Offender had intention to kill and killing was not attended by any qualifying circumstances of murder and or by that of infanticide or parricide. So no offense of frustrated homicide through imprudence. The element of intent to kill in frustrated homicide is incompatible with negligence or imprudence kasi yung pag reckless imprudence or resulting to homicide, iba naman yun eh. Iba yung penalty. Yung pinapunish dun is reckless imprudence eh. I think na-discuss ko sa previous video. Pero pag homicide, may intent to kill. Sa imprudence or negligence, wala kang intent to kill kasi. The refusal of the deceased to be operated on or undergo medical intervention to save his life does not relieve the offender of criminal liability for his death. Intent to kill is conclusively presumed when death results. An exception is if evidence of intent is crucial to finding of attempted or frustrated homicide. Accused is liable for physical injuries if there is no intent to kill on the part of the offender in an attempted or frustrated homicide. If the death of a person is brought about by a lawful act performed with proper care and skill and without homicidal intention, there is no felony. So accidental homicide if the death of a person is, again, brought about by a lawful act. Yung corpus delicti, it means the fact of the crime. Hindi yan yung body of the crime, hindi yung body ng victim. That a crime was actually perpetrated and does not refer to the body of the murdered person. Yung act of killing yun yung corpus delicti. Okay. So, penalty for frustrated parricide, murder, or homicide, Article 250. Courts may impose a penalty of 2 degrees lower for frustrated parricide, murder, or homicide, 3 degrees lower for attempted parricide, murder, or homicide. The imposition of a penalty lower by 1 degree than that imposed under Articles 50 and 51 depends on the courts in view of the facts of the case. In other felonies, a frustrated felonies penalty is the next lower in degree for that of consummated and 2 degrees from that of frustrated. Wait lang, mali yung notes ko. If it is in the attempted stage. Under PD number 1110-A, any attempt on or conspiracy against the life of the chief executive or the president or member of his family or against the life of any member of his cabinet and the latter's family shall suffer the penalty of death, pero walang death penalty ngayon, so suspended, so reclusion perpetua. So yung mga next, like tumultuous affray, physical injuries, discharge of firearm, infanticide, intentional abortion, unintentional abortion, abortion, mga ganyan. Dual, hindi na siguro kailangan. Wala naman na to. Mutilation. So, sa next video na lang yan. Medyo mahaba rin kasing serious physical injuries eh. Rape. Rape is crime against persons na ngayon. Tapos, separate video naman yung special penal laws. So, hati-hatiin natin. Okay. See you.